Hello friends, in the series on income tax cases, today we will discuss a very important case which has been decided by Honorable Gauhati High Court, and the issue before the Honorable Gauhati High Court was that if the assessee do not challenge the jurisdiction of the assessing officer to issue the notice to the assessee either during the assessment proceedings or during the CIT appeal proceeding. So whether in that case he can first time come to the tribunal and said that the assessing officer was not having the jurisdiction over the case. This issue has been decided in the case of Commissioner of Income Tax and another versus SHANKAR LALL GOENKA, and this case is reported in 481 ITR at page number 690, and the date of the judgment is 25th April 2025. In the present case, the assessee was having the taxable income more than 20 lakh. The notice under section 143 subsection 2 was issued to the assessee by the income tax officer. Since in the present case, according to the monetary limits, the notice to the assessee should have been issued by the Deputy Commissioner of Income Tax. So the file was transferred from Income Tax Officer to the Deputy Commissioner of Income Tax. When this file was received by the Deputy Commissioner of Income Tax, then he didn't issue the notice under section 143 subsection 2 to the assessee afresh, and on the basis of the notice issued by the Income Tax Officer, he proceeded with the assessment and some additions were made. When the matter came before the CIT appeal remanded the matter back to the AO for reconsideration. The assessee challenged the order of the CIT appeal before the tribunal and raised an additional ground that in the present case, the assessment completed by Deputy Commissioner of Income Tax without issuing the notice under section 143 subsection 2. And the tribunal not only admitted the additional ground but also entertained the additional ground of the assessee and quashed the assessment proceedings on the basis that the jurisdictional assessing officer has not issued the notice to the assessee under section 143 subsection 2. The revenue filed the appeal before the Honorable Gauhati High Court, and the court said that in the present case, the assessment cannot be treated as invalid merely by reason of any mistake or defect or omission in the notice. The court said that section 292B says that an assessment cannot be treated as invalid merely by reason of any mistake, defect or omission if they were in substance and effect in conformity or according to the intent and purposes of the Act. The court said that in the present case, when the tribunal passed the order, the tribunal did not give the finding that the notice under section 143 subsection 2 was not in substance and effect in conformity with the provisions of the Act. The court said that in the present case, since the assessee has not challenged the jurisdiction of the Deputy Commissioner of Income Tax either during the assessment proceedings or during the appellate proceedings, so in that case he loses his right to challenge the jurisdiction first time before the tribunal. The court said that in the present case, the tribunal has erred in entertaining the appeal of the assessee and said that the assessment cannot be quashed because the assessee has not challenged the jurisdiction before the assessment proceedings or before the CIT appeal proceedings. Friends, although there are very contradictory views on this aspect, and the courts have given relief to the assessee because they said that once the AO do not have the jurisdiction, then the whole assessment proceedings are bad. But the Gauhati High Court was of the opinion that since the assessee has participated in the assessment proceedings without challenging the jurisdiction, so he do not have any right at the time of the ITAT to raise this ground. So friends, the message is very clear from this case that in near future these type of judgments may come. So it is always advisable for the assessee to raise these grounds at the earliest stage so that he can take the benefit of the jurisdictional grounds. At the end of this video, once again I am repeating the name of the case. The name of the case is Commissioner of Income Tax and another versus SHANKAR LALL GOENKA, and this case is reported in 481 ITR at page number 690, and the matter has been decided by Honorable Gauhati High Court on 25th April 2025. Thank you, friends.